Welcome to A Lawyer's Guide to the Galaxy, a podcast about geek culture by lawyers with your hosts, Ben Siders and Kurt Damon.
And welcome back to A Lawyer's Guide to the Galaxy, the podcast that asks interesting questions that don't have any answers with your host, Ben Siders. That's me. And the other guy is Kurt Damon.
As always, Kirk Cousin, the captain of the Enterprise.
We are intellectual property lawyers and certified geeks practicing law in St. Louis, Missouri. You can find me, Ben, on Twitter at Benjamin Siders. You can find Kirk at KirkDMN. You can find the podcast somewhere, but nobody engages with us on Twitter, so that's probably not the best spot anymore.
Well, it's because Twitter doesn't exist anymore. They can't engage us on Twitter.
We're still working on getting everything kind of lined up on YouTube. That might wind up being the best place down the road, and someday, in some future alternate reality, we will have a website again.
We do have content on YouTube if you guys want to check it out. I mean, if you haven't checked it out, there is content on YouTube. It's just not complete.
Yes, that is correct. I don't think we've been updated since July or August, but
yeah,
we'll get to that, I promise.
So if you're listening to this, you're not listening to this on YouTube currently.
Obviously.
You're probably, or at least not in real time. You're probably listening to this either on something that isn't YouTube, or you're listening to it on YouTube some point in time in the future, and you're wondering what on earth are we talking about because everything's up on YouTube by then.
We are recording in November of 2025. For those of you who are going through the back catalog, and what has been in the news recently is an unusual step taken by the United States Patent and Trademark Office to institute something called ex parte reexamination of one of those Nintendo patents that has everybody so damn mad.
So yeah, we're talking about the Nintendo patents again. We intended to do one episode on this, and this is now our third.
Well, things keep happening.
That's the thing. It's amazing sort of how this has stuck and been in the news. Now, it is interesting, just generally that's what it is, and that's why we keep approaching it. We have had a lot of interest from our listeners around
It's interesting
this.
To us. I'm surprised it's been this interesting to normal people.
Well, I think part of the reason for it is, I think, one, it involves Pokemon, generally, and Nintendo's association with Pokemon, so Pokemon video games. And so I think that's part of it. I think part of it is it's bouncing around the gaming community. And to sort of our earlier episodes, there was a lot of just extreme statements, let's put it that way, around what this meant coming out of Nintendo. And that's what's gathering the public's attention. My take behind it is, what it was, and I think what we had sort of in our prior episodes, is that a lot of those extreme statements may not have necessarily have been appropriate, may have been a bit premature. And that's what we sort of talked about. So if you guys haven't gone through and listened to the two prior episodes, I'd encourage you to do so. But if you haven't done it, just sort of as a brief overview, our first episode, we sort of focus on that media response and the idea that, it's not necessarily correctly portraying really what the patents talk about. It seems to be a bit for shock value.
To summarize briefly, the media response about the Nintendo patents being granted was a combination of, at best, I would say, hyperbolic and misinformed, and at worst, downright misleading.
Yeah, and it was hyperbolic. That's a good word to put to it.
And then our second episode was, and the point was raised in those media articles that we looked at in our first episode. How come the patent office didn't find any of the obvious prior art that we all know exists, although nobody can put their fingers on?
Yeah.
And our second episode, we tried to find it, and we couldn't find it.
Yeah, we tried to look into gaming in our second episode, and particularly sort of what can we find that's out there about how games operated and stuff in this time period. Did some YouTube research, things like that. Now, one of the things that was raised in our first episode, I think it's important to talk about. A lot of the commentators' complaint was, why did this patent go through so easily, which it did.
Which is unusual.
And that's unusual. And we even commented about that in the first episode, the fact that this was unusual, and that the commentators do have a point in that. I'm not sure if that came across necessarily in the first episode all that well, but if the commentators' hyperbolic analogies have a point, the point was, why wasn't this more thoroughly examined? And what we sort of came to the conclusion was probably because they couldn't find prior art.
That's usually why.
What I think we're going to say a point on this episode is the prior art was out there and findable. That's what we sort of had missed, and I think we missed it as well, in the course of doing it. Our second episode, we focused on games and what is there out there for games that exist. What we didn't focus on, and what the patent office is focused on, is other patents.
Right, which is the better prior art. So that's what's happening now. So here's what's happened. The director of the United States Patent and Trademark Office has the authority to institute this procedure to re-examine a granted patent. There's actually a couple procedures for doing this. Most of them require a third party to petition the patent office to have that done, or the patent owner can themselves petition the patent office. We have something called a reissue application, where you can file shortly after your patent is granted to have it looked at again and then reissued on the basis of prior art you find later. Doesn't happen very often. I don't think I've ever done it. There's also the what's called the AIA proceedings. That's the America Invents Act. These are the proceedings that people are mostly thinking about when they think of, I'm going to have that patent invalidated. You file a petition, you pay an ungodly amount of money, and then the patent office looks at it, and you have a contested proceeding where the petitioner, who's usually somebody being sued for patent infringement over that patent, is trying to have it thrown out without having to do it in court first, because it's a lot more difficult and more expensive in court. So.
Yep. And what we basically keep in mind, these are all proceedings at the patent office. These are not court proceedings.
Administrative trials. Yes.
You can always get a patent thrown out in the courts. That's
that's not changed. In fact, I just saw an article this morning where somebody said the patent office is trying to make bad patents bulletproof. Well, they can't. Okay? They don't have the authority to do that. They can control their own proceedings because Congress passed a law saying they can control their own proceedings. If we don't like that, Congress needs to change that law. But they can't control what the courts do and don't do, and the courts always have plenary authority to throw out bad patents.
Yeah, and that's the key thing to keep in mind is these are proceedings at the patent office, and the reason these proceedings exist, the idea behind them, was to basically say the patent office has some expertise under what should and shouldn't be granted as patents. So if something arises that says that there was a mistake made in the process of granting a patent, there should be a way to go back to the patent office and say, hey, can we rectify this mistake?
Without having to go through a court to do it, which has a million types of cases it deals with, and patents are a tiny piece of that.
A court also can only say the patent is invalid. They can't modify it to grant something which is valid. They can't fix it.
So the idea behind these procedures is not just to throw out bad patents, it's to fix the problems with them. And frankly, the procedure that's been implemented here, ex parte reexamination, is a very old procedure, and we've done a couple. I've never lost one. I've never had a patent get lost in this procedure. What usually happens is that if there's a problem with the patent, it just gets fixed.
Yeah.
The language is changed or modified or narrowed to work around whatever prior art is there. But there's a kind of a popular misconception I've seen, at least on Reddit, sort of misunderstand what's going on here as, the patent office is now going to throw this out. Well, they might.
Yeah.
I think having not looked at the merits yet, I think that's probably unlikely just based on how this procedure usually goes. Nintendo gets a chance to argue for why it's fine the way that it is, and if not, to change it and narrow it to work around whatever other prior art they've got. So there's a very good chance, all else being equal, that the patent is not only not thrown out, it may even be it's going to be made stronger, harder to invalidate, by fixing whatever flaws may be in it.
Potentially, yeah. And I think the key thing to keep in mind about this is that this is one of many what are called post-grant procedures. And they're very different in the way post-grant procedures work. So there's re-exam, there's reissues, there's IPR, and there's what's actually called a post-grant review and sort of things like that. Those are four very different procedures. They have different requirements for what they take to institute. They have different ways that a patent can or cannot leave them. And they have all sorts of different ways they're carried out and the evidentiary procedures underneath them. So one of the problems that I think we're seeing a little bit in the commentators behind this is they're kind of clustering these four procedures together and saying, what happens in one of them is also what happens in the other. And the answer is that's not true. The best example behind it is reissue. Because if you compare all four of these,
that's the weirdest one.
One of the things reissue can do is you can reissue with a patent that's broader than it goes in. You can actually get more patent protection reissue than you would in any of the other procedures, because the other procedures require limitations that say if you're going to amend the case, it has to be narrowing.
Yeah, or at least no broader.
Or at least no broader. And so what you kind of bump into around these kind of things is, I think some of the first things in the commentators is they're collapsing these four different procedures into them.
Yeah.
And this is a big deal because IPR procedures, for example, patents tend not to survive. Whereas re-exam and reissue patent procedures, they tend to survive.
Yeah.
So if you look at it and say, hey, we're going to conflate the two together, and that means it's not going to survive. No, it's not really accurate. You're using the wrong procedure and thinking of the way this thing's going to interact.
Here's the quick difference amongst these. The IPR procedure, that's inter partes review, which is Latin for among parties, which just means that there's a third party involved that's fighting and arguing, not just the patent office looking at it again.
Yep.
That procedure is contested. It usually happens after a patent owner files a lawsuit accusing somebody of infringement. They then do a prior art search. If they find prior art that they think was not already considered by the patent office and could invalidate that patent, they petition for IPR. And as Kirk said, if it's instituted, it usually invalidates at least some, sometimes all, of the patent.
Yep.
And if you're being accused of infringing, you sometimes don't need the whole patent to be invalidated, just part of it. There is the opportunity to amend and change the claims during that procedure. My understanding is that doesn't work very often.
It's very limited in the way you can do it. It's a very particular procedure. When you do it and how you do it are also both very limited.
You have to get leave from the judges. So anyways, but that's not the procedure that's at issue here. What's at issue here is this older ex parte procedure where a third party can tell the patent office, hey, I know about some prior art that I think is relevant. You didn't consider it before. You file this petition for ex parte reexamination where you say, this presents what's called a substantial new question of patentability. We're not just repeating the same arguments that have already been made or filing cumulative prior art that don't really say anything new or different. It's a new reference with different issues for the examiner to consider, and the patent office will then look at that, and if they agree, they'll institute this reexamination proceeding, which then proceeds ex parte, which is just between the patent office and the patent owner, just like when the patent was originally sought.
Yep, and that's one of the key things behind sort of the difference between ex parte and IPR, which is inter partes. And again, those are the fancy sort of, Latin terms that, lawyers use. Ex parte proceeding means the person who instituted it, unless they are the patent holder, isn't involved in the proceeding.
That's a good point. The patent owner can also petition for ex parte review of their own patent.
And I've been involved in ones that have done that because you may have a situation where something arises where you look at the patent and say, we may have a problem here, but we know how we want to amend it. We know we can get it around and we want the amendment to be entered.
Yep.
So have us look at it, decide if you think we're right or if we actually are wrong and it doesn't need to be narrowed. If it does need to be narrowed, here's how we want to narrow it. Now we think it's fine. Patent office, do you agree? And they say yes. A lot of times, yes, we agree. Or they may say no, we don't agree. The danger of any kind of ex parte proceeding is once it's opened, the first
two ways
patent's
out.
kind of gone.
Yeah.
And so you're either coming out with a sort of new patent, even if it's the same,
or none.
And so it's one of those things where, you always be a bit cautious of, do you want to do that on your own? But in certain circumstances, you definitely do want to do that. You want to have the examination. So ex parte can be instituted by any person.
Yeah, the patent owner can do it, the patent office can do it, or a third party can do it.
But that person is not involved in the procedure. It comes down to the examiner and the inventor, the representative in that case. In inter partes re-exam, the inter partes re-exam is instituted by a third party and the third party participates.
And it's not back in front of the examiner. So a re-examination is just redoing the patent examination, not quite from scratch, but it's the same basic process on an accelerated time frame. You have a patent examiner who works for a special division of the patent office called the Central Re-examination Unit, and they specialize in this type of prosecution, whereas the IPR proceeding is more like a condensed administrative trial in front of patent law judges, not patent examiners.
And the other thing to keep in mind, as we sort of said with it, the IPR proceeding was only instituted in the AIA, so it's only about 20 years old.
Not even. I mean, that's 2012, 2013, so it's 10 years and change.
10 years and change, behind what it is.
Re-exam's been around for decades.
Yeah, decades. I mean, the re-exam's an ancient procedure that's existed forever. And actually, one of the arguments behind IPRs and the creation of the IPR procedure was because they didn't like the fact that the third party didn't get to participate. So the whole idea was to create a situation where the third party did get to participate.
It's risky if you're a third party petitioner because you file this petition, you've got this good prior art. Are you better off doing this, or are you better off using it to defend yourself in front of a court?
Yeah.
And in a court, you at least get to make your arguments for why you think it's relevant. But with ex parte, you don't. I mean, you kind of make those arguments when you petition.
You have to make it up front. Yeah, it's a petition.
But once they institute, all you have to prove is that there's a substantial new question of patentability. That doesn't mean that the patent's definitely invalid or even possibly invalid, just that the new prior art is relevant and was not considered before. That's basically what they're looking at.
Yep.
And after that, you lose control of it and it just goes through the re-examination process. So you could wind up inadvertently strengthening the patent and making it harder to assert that same prior art in court, because if you do, the judge is going to say, well, look, the patent office already looked at this. They said it's fine. I'm not going to go back and redo that.
And they specifically looked at it. That's what the procedure's on. It's not even like they had it available to them and they could have looked at it. No, they did, and they made the determination in light of it. The other key thing to keep in mind sort of behind it is if you're in court, where we said the court has one option. The patent's valid or it's invalid. That's the only decision they make. In the patent office, if they say the patent's invalid, the patentee can try to modify it and come back with a modified case.
You can add new claims, which again is why they're not always invalidated in whole or even in part. And I would say, I mean, I think I've done 5 or 6. None of mine have been invalidated. They all got granted. That's not unusual. It's not like a humble brag or anything. It's just that's how the procedure works. So I also this commentary about how I see these headlines. Oh, Nintendo's finally going to get it, and people are celebrating and dancing in the streets because they're so mad about this patent. That may or may not happen.
Yeah, and that's the thing to keep in mind about the procedure. I think they're looking at the IPR, what happens in the IPR procedures, and saying, that's what's going to happen in this case. And the answer is no, these are very different procedures. And again, the real key thing to keep in mind about the ex parte procedure, and it's the reason that a lot of alleged infringers didn't want to use it, is because they can amend and get out of it. So if you say, it's kind of like looking at it and saying, hey, I think you have this thing. If it's invalid, and it's your only bite at the apple, well, I can do what I'm doing. There's nothing you can do because your patent is invalid. If I file the ex parte proceeding, you may come back and say, yes, that patent's invalid, but I'm entitled to another one you also infringe. And that one now becomes more valid.
Yeah.
And so you kind of bump into this thing where it's like, do you really want to do that? Where you have the binary, it is or it isn't, versus if it isn't, you can still change it. If you're on the wrong side of that patent, you don't necessarily want that possibility to exist, which is why the ex parte procedure wasn't really used a lot by third parties,
and still isn't. It's pretty uncommon.
It's used occasionally, definitely as to what it is, but it is actually used by patentees, I think, on a reasonable common basis, as is reissue.
There is one thing that's very unusual here, and that is that this was not a third party instituted or the patentee. It was the patent office, which mostly does not want to go back and second guess itself.
The patent office has the authority to implement this. Anybody has the authority to implement this, so they completely have the authority to implement this as to whatever it is. But basically what this is the head of the patent office coming back and saying, we think the patent examiner in this case made a mistake. That's essentially what they're saying.
I would slightly disagree. They're not saying they made a mistake. They're saying they didn't find this prior art or consider it. That may or may not impact whether this patent is valid, and if it is, what the claims have to say.
I guess the way I think is, I wouldn't say they made a mistake in granting it. They made a mistake in examining it.
Yeah, possibly. Or you could say they didn't find this prior art for whatever reason, or if they did find it, which I didn't check the...
No, they didn't find it.
It wasn't... Okay, yeah. So the art that the patent examiner considers or has available in front of him or her in the course of examination is all printed on the front of the patent. So you can look and see if a given reference has already been in the record, so to speak. If not, that is your strongest basis for getting an ex parte re-examination started, because the patent examiner never found this art in the first place, so obviously it could not have been considered.
And that sort of gets back to our initial points where we said one of the interesting things about this case, and what a lot of the commentators were sort of saying underneath the headline, was one of the issues with this is, why did the patent office grant this so easily? And the argument behind that is the examiner didn't seem to really find any prior art, didn't cite very much prior art, and so it went through very easily. Shouldn't they have found the stuff associated with these gaming? And again, a lot of our response in sort of looking at that was, some of that stuff is hard to find. Yeah. What they'd really be looking for is patents. These two patents came up, and you see them now sort of being cited by the office, is kind of the office looking at it and saying, actually, there are patents out here which probably should have been looked at. And the fact that there weren't any looked at does render the commentators are right. It does render the concern of, like, why did this get granted so easily? It's not that it shouldn't be granted, but it looks potentially concerning because of the way the process went through. So let's have the examiner look at these. And if you look at the actual institution statement, what the head of the patent office, John Squires, said about it, he particularly focuses on one of the things the examiner said. And the examiner says in the notice of allowance why they granted the case, that they didn't have any prior art related to controlling two different characters and between the two different characters and switching. That's
interesting,
characters.
Kurt, because when you and I looked at that patent and we looked at the reasons for allowance, we kind of went through the claims, looked at the reasons for allowance, and I felt there was not a huge gap, but a slight mismatch between how what the claims said was being characterized in the reasons for allowance and what they actually said. And I felt that the examiner was, I think, reasonably, but still drawing a bit of an inference about what the claims were trying to say. And so it didn't quite map completely. And that I thought was a little unusual, because most examiners will just cut and paste the exact claims and say, here's what they say, I couldn't find it. And it's really that simple. This one went on to say, these two different battle modes aren't really shown, but the claims didn't use the word battle modes. It used different language. So what's been instituted now is this ex parte re-examination on the basis of new prior art the examiner did not see before that does talk about two different battle modes.
And I think that's the real key, is the fact that John Squires focused on this. And again, the reasons for allowance are oftentimes not referred to, particularly in any kind of proceeding, because it's usually an examiner just kind of restating what the claim says, so it doesn't say anything. The answer to it is A is not shown in the prior art because A is not shown in the prior art. It's kind of what they say.
Yeah. The claims recite element A. I couldn't find it, therefore it's patentable, which is correct. That's how the law works.
Yeah. What it kind of said in this one is you kind of look at the reasons for allowance. He said A is patentable because A prime wasn't in the prior art, and the offices come back and said, actually, A prime was in the prior art.
Yeah, so even if that's how you interpret it, we've got something we think is pretty close to that.
Yep.
Now, it's not all in one application, right? It's not all in one reference. So this isn't a case where, this exact thing as claimed is out there, but the piece that the examiner couldn't find...
one of the pieces couldn't find.
May be, and so we want to go back and we look at it and say, now that we found that, one, is it that piece? And if it is it obvious to modify the prior art and put it all together in this way?
Yep. And I think the other thing to keep in mind with it, and this is the other thing I think with the people talking about what the procedures are and the specifics of the procedures, is it's very interesting to have the head of the patent office doing this, because he now sent a patent into ex parte re-exam. At the same time, he is actually prohibiting a lot of IPRs from happening. The director has the authority to determine whether or not IPR which is being instituted should go forward. And he has basically stopped all of them that are currently pending.
Which a lot of people are mad about.
There's a lot of people mad about that. There is a court case that as to whether or not that's inside his authority. They just said it was inside his authority. But it's, again, focusing on the fact there's two different procedures here. He has looked at it and said, I'm going to purposely implement one of these under one procedure, which is rarely used, while simultaneously stopping ones under procedure, which is commonly used.
Yeah.
So there's a lot of, I think one of the things that's pervading this is there's a lot of, for lack of a better term, politics in the patent office that the commentators are just plain missing.
Yeah.
Of the fact that, there's interesting stuff going on around this, which the patent community understands and is kind of implicit in the discussions, which I think is getting out to the community as a whole, but isn't getting out to the community as a whole in the way it's understood by the patent community as being very interesting.
I go one further. And this is just my take. When I look at ex parte re-exam, to me, it's a procedure that is used to invalidate patents by the third parties who use it. That's what they want.
Yeah.
But the procedure itself, I feel like, is designed to fine-tune and adjust patents.
Yeah.
It's not
to make them better. Really.
Yeah, it's not really calculated to get rid of them unless they really are invalid. Well, then they need to go. But the procedure is designed to do what it says, to re-examine and then reissue a new patent if still valid. IPRs are different. It is a procedure where the deck is kind of stacked against the patentee. Mm-hmm. Once it's instituted, you're probably going to lose at least something. It is rare to win those. And it's because the way that it's...
For a while, it was impossible.
It was almost impossible. And I think it's designed that way. It is a procedure that was added to make it easier to get rid of patents. Not fix them, get rid of them.
Yeah. And that's an important sort of political distinction, is the idea of we're using a procedure which is designed to improve patent coverage, to be more accurate, versus a procedure which is designed to eliminate patent coverage that we don't like. And again, we've seen the patent office seems to be saying, hey, there's a lot of this use of procedure to eliminate patents we don't like, and arguably what's been abusive. There's been arguments it's been abusive on one side of the equation. And now the argument is, but hey, not letting us do it is also abusive. With the patent office coming in and saying, but we'll have this other older procedure which is designed to sort of refine and improve patents, and we should be using that potentially more. Mm-hmm. And we're going back to sort of a pre-AIA. So we're going back to sort of early 2000s practice here, in the way this thing worked, which is very different. And whether or not re-exams were uncommon back then, IPRs became very common.
And they get even more uncommon.
And re-exams became even less common because of the fact that IPR is out there. We seem to have the patent office saying, actually, that sort of earlier procedure might have been better. And maybe we should go to that. So there is some interesting politics here that I think some of the commentators are picking up on, but they don't necessarily understand sort of the exact nature of that politics. But the community, the patent community, is part of what's influencing what they're talking about.
Let's get into this prior art. Is it any good or not, Kirk? I haven't read it.
Let's talk about what we've got. Basically, the examiner said there that the director said there are two pieces of prior art. They are both United States patent application publications. From what I can work out, I believe both of them sort of have ceased to be prosecuted and being actively pursued. One I know has, I believe the other one has too. There are two of them. The first one of which is to actually Konami. So, obviously a competitor of Nintendo. And it has to do with some of the game stuff. It's a very old publication, actually. It was published in 2002.
By gaming patent standards, that is ancient.
Ancient, yeah. And very interesting, sort of into what it had with it. The second one is another patent filed by Nintendo, which is unrelated to the current group of patents that are talking about here and sort of current family of patents related to here. Interestingly, the patent also specifically relates to the Nintendo Switch. So if you look at the patents, you'll notice that the first drawings in both this patent and the one related to the pet have to do with drawings of the Nintendo Switch. And there's actually quite a bit of discussion in both patent disclosures about the operation of the Switch as a hardware device, even though they relate to software, and sort of software applications around it. It's clearly not to Pokemon Go. It's to a very different game, I guess you'd say, around it. It involves capturing characters, but I don't think it involves Pokemon specifically in the way we do it, because it doesn't really involve balls. So that's sort of the way I'd put it, but it does involve the concept behind sub-characters and sort of teaming up and fighting battles together. So what the argument with the Patent Office and what the Patent Office said in its institution is both of these patents relate to providing alternative battle modes, which you switch between. Unquestionably, these patents are directed to that. That's what these are directed to. Without any question. The interesting thing about it, I think the Konami case is sort of the more interesting to look at. In the Konami case, they even use the same language, a character and sub-character, but they are not talking about a pet as we think about a pet like World of Warcraft or, a pet in the way of a Pokemon. They are talking about you having two members of a team, a main character and a sub-character. And the way I read them, and admittedly, I read these fairly quickly. I didn't want to go through and spend huge amounts of time. They're relatively long disclosures, not huge by patent standards, but, a little bit longer. But basically what they seem to be more associated with is if you have two members of a team, but one player, how do you switch between them in a combat situation? So the idea with it is that you have player, your main character is fighting. You can then instruct your sub-character to attack something, which it's going to then do. Then you switch back to your main character to carry it out, and the sub-character keeps attacking.
Okay.
Because you told it to attack. And then at some point in time, you may have a scenario, the way they show it. These are all like, again, I don't know what the game is, but they kind of show these, you may recognize it as to what it is.
They look like anime characters.
Yeah, anime characters and a ninja sort of attacking them, and obviously sort of, computer ninja attacking them, all of which amusingly enough are literally look like clip art. They're all the same, exact same picture, flipped around. But basically sort of saying, what we have with it is both characters are fighting. You may have a third enemy arrive. When the third enemy arrives, the main character may not want to fight the third enemy. They may want to keep fighting what they're fighting, but they may want the sub-character to go attack the new enemy, which they normally wouldn't do. They'd keep fighting until the enemy they're fighting is dead. So it allows you to switch to the sub-character, direct the sub-character to go attack a new enemy, and then switch back. So that's kind of if you talk about it as being two battle modes, this is unquestionably two battle modes. I mean,
you know what it reminds me of though? The old baseball games in the 80s and 90s where you would control the batter, but once you get a hit, you can switch and control a runner, or even like the Madden NFL games, you can switch from the quarterback to the, you can change which character you're controlling.
That was a combat game.
Obviously, combat game is different, but you're going to tell me football's not combat? Yeah. Come on, Kirk.
Well, but I actually thought it was interesting after you said those. I immediately thought the soccer games actually the exact same thing. But the idea of where you switch between characters where it kind of tracks the ball, and so you're always playing. And the reason I remember it is because I remember a friend had a Nintendo and had a soccer game, and I had the worst trouble controlling it because you were constantly controlling the player with the ball.
Yeah.
And I wouldn't realize that I'd switched to the person I'd passed to. I'd think I was playing the character I'd passed, and then I'm like, wait, but that one now took over automatically. Now, those did it automatically. That was typically the way you saw a lot of those, where it was, again, if you passed the ball in football, you would then play the receiver when they caught the pass. This is saying, no, you still want to play the main character, but you need to change what the sub-character's automated routine is. In particular, to go get them to attack a different combatant which has approached you.
I feel like even with this, it's still missing a couple of elements from that original case. It had this idea of, depending upon where in the field of play the pet or the sub-character appears, affects the battle mode. This doesn't seem to have that piece of it.
Yep. Now, again, I think the key about this is we didn't look at this. I didn't look at this in conjunction with the other patents that were cited. Again, there wasn't really any art cited in the main Nintendo patents, so we don't know what else the examiner maybe else be out there. But when we talk about the idea of what the director said, quoting it, the examiner said he didn't have patents related to two battle modes. This Konami patent unquestionably is two battle modes.
Yeah.
Now, whether they're the same two battle modes or whether they need, additional elements, stuff like that.
Different question.
That's not raised. Yeah. It's a different question. But if you treat the examiner at his word, the piece I don't have is two battle modes.
Well, here it is.
Here is two battle modes. And I think that's the thing with it. And I like the Konami patent, quite frankly, looking at it. partially because it even talks about it being a character and a sub-character. Like they literally use the same language.
You know what it reminds me of, Kirk? We talk about this when we did our Two Live Crew case about fair use at the Supreme Court and copyright. There's sort of this misunderstanding amongst especially non-lawyers that, oh, well, if you're doing parody, that's always fine because the Supreme Court ruled in that case. But that's not what happened. What happened is that the lower court said that parody is, as a matter of law, never fair use. The Supreme Court said, well, it can be. In fact, sometimes that's one of the strongest cases for fair use. Go back and do it again. Then the case settled before anybody could rule on whether it actually was fair use in that case. That's also what happened in the Alice Walker case involving the Win Done Gone. A lot of these cases, once you win or lose on the law at the appellate level, the case settles after that, and we never actually get the true ruling on the merits that is ultimately upheld. We just get the ones that we know aren't correct, not because they're wrong, but because they got the law wrong. For all we know, getting the law right, they might still come out the same way. This feels the same way to hear. The director is saying, you didn't have two battle modes. Well, here it is. Go back and look at it again and make sure that now that you've seen this, you still think it's patentable, which very well may be what happens.
Yes, and I think that's the real key thing to keep in mind with this. And again, if we look at the Nintendo patent, I think the Nintendo patent is interesting because obviously it involves the Switch. Nintendo obviously knew about this patent publication. It's theirs, and it relates to similar type stuff. It also talks about a character, a sub-character, using the same language. We started seeing here again. And now it's Nintendo using the language in two different patents. It relates to the Switch. It has the same kind of hardware discussions about the Switch. These two cases are clearly sort of related to each other. One of the things but it doesn't talk about all the pictures of gameplay are different. It shows different stuff around it. And in this case, it's not so much talking about the idea of summoning a Pokemon. It's using a second character in the process of capturing or attacking an enemy. So what we again see is we see the patent saying, hey, look, here's another case about two battle modes. The argument was you didn't have two battle modes. I have two cases for you that show two battle modes. Are these the same two battle modes? Do they talk about the idea of like pet summoning, what we see in the Nintendo case? That wasn't the reason this was instituted. This was instituted because the examiner said, I didn't have two battle modes. And the director saying, here is two battle modes.
Yeah.
Now, the answer to it is the examiner may not have other things. He may still think it's patentable in light of this, it's whatever it is. But he said he didn't have two battle modes, and so you have two battle modes.
That's really the headline, and that's one of the reasons why we wanted to do this episode is that, hopefully if you've seen any of these articles talking about this, you see where the disconnect is. There's this just pervasive attitude that, I've seen things like, massive blow struck against Nintendo.
Yeah.
I'd say more of a glancing blow. Like, okay, this is an annoying, expensive thing they have to deal with. Based on what we've seen, it might have to get changed or refined or made more specific. I would be surprised, having not looked at this in detail yet, but my immediate gut instinct is that I would be surprised if this patent was invalidated in its entirety based on this.
I think the one thing to keep in mind with it, and I think something the commentators are catching on, I'm going to disagree with you slightly. And the reason I'm going to disagree with you slightly is I think the fact of the way this was instituted and what was instituted, you've now got to have that examiner disagreeing with the head of the patent office.
But see, I don't think so, though, because the standard to institute is substantial new questions.
Yes.
The examiner didn't say, I think it's invalid, go look at it. He said, I think you didn't consider this, go look at it. Now, there may be some subtext there.
There's some subtext there is what I would argue.
Going back to my court example, the courts will sometimes, in the concluding paragraph of an opinion, clearly telegraph how they think the lower court opinion should come out the next time based on this quote-unquote clarification of the law. Having not read the institution order here, I don't know how exactly Director Squires put this. So there may have been some subtext there that I just don't know about.
I'm not sure there's any true subtext, but I think there definitely is a read between the lines. And just the reason I'd say the reason between the lines is because this is a patent that has gotten a lot of press. I think it is important to note Nintendo is not an American company.
And Japanese companies, anecdotally, Japanese companies don't like to get involved in disputes in U.S. courts. They just don't. Most foreign companies don't.
And so, Reynolds is not a U.S. company. So, it's something where, in some sense, it's a, for lack of a better term, safer target for something for, a director of the United States government to go after. And I think you have the subtext of the fact that this was such an uncommon procedure for them to do it. in light of the media frenzy.
I think I read this is the first time in 10 years that there's been a director. I don't remember the last one.
Yeah, I can remember one, but I can't remember if it was one that I was researching something and learned about had happened, or if it was one I actually remember happening. I literally can't remember, what it was. So it's
That's how uncommon it is. There have not been many.
But I think part of the thing with the subtext behind this, and actually what I took from it, is quite frankly, this is what should have happened. Because basically what we had happen is we have the Nintendo get these patents. A bunch of commentators and reporters researched this and said, look, the problem with this patent is not that it's necessarily invalid. Again, if you get past the headlines and you read the text, the problem is that it looks like it wasn't really thoroughly examined. The director looking at it and saying, when I review this, it actually doesn't look like it was necessarily thoroughly examined because he said he couldn't find this thing, and I managed to find some stuff as to what it is. Then go back and look at it. So go actually do the thorough examination that probably should have been done. That doesn't mean the claims are invalid. That just means that, yes, there is an appearance of impropriety, one of those things that's thrown occasionally around in law.
But that's important too, right?
That's important.
The legitimacy of patents depend on people being confident that we're doing a good job looking at them. That may also be what Squires is concerned about.
And I think what you're going to see come out of this, quite frankly, is I think the examiner is going to look at this, and whether they allow the claims or reject them in light of any of this art, I think you are going to see a very detailed, very well thought out statement as to why they are coming to
I would not be surprised if there is a rejection, at least initially, to make Nintendo put some arguments on the record. You're not going to do a substantial new question and then just rubber stamp the patent. There needs to be a rejection and some argument. That's what almost always, I've never seen a case where that did not happen. I would also be curious, I think we were going to check on this and couldn't figure it out, but the Japanese version of the same patent was rejected at the Japanese Patent Office. I wonder if this is the art it was rejected based on.
Yep, and we just literally forgot to look that up.
Yeah, if so, there's two interesting wrinkles there. One, if you have the same subject matter pending before a foreign patent office and it's rejected, you're supposed to tell the U.S. Patent Office about that, except in one circumstance, which is where you've already gotten your case granted, so there's nothing they can do about it anyway. So if the Japanese version was rejected after this was granted, this is the only way to say, oh, hey, a foreign patent office found this reference. We need to consider it here.
And actually, again, I kind of fall back on it. I think to me, the thing behind this is, we talked about in the first episode of our podcast around this, that a lot of the commentator comment was, it just didn't look like the examination was done well. And we kind of agreed with them. It does have that look to it.
It looks like it,
It looks like it. I'm not sure it was done poorly or anything like that.
Not that you can't ever get a grant on a first action. That happens. It's unusual, but it's not unheard of.
Yeah, it happens on a somewhat regular basis. I would say, again, it's not 50% of cases, but it probably safely 5.
It's
maybe
probably
10.
more than that. Yeah, depending on the art, anywhere from 5 to 15.
Yeah. And so, that kind of thing. So it's not that to say that anything was done wrong, but there's an argument to say this is an important case, and there is this potential appearance that something was done wrong. Given that scenario, the obvious solution would be, well, let's see if we can actually make sure it was done right, which is exactly what's happening.
Which is what this procedure is for, right?
Yeah, that's exactly what this procedure is for.
Take it back, do it again. Let's take a second look and make sure we're still confident in the outcome here, now that we have the benefit of this other reference.
And that's what we're kind of pouncing on the commentators again, where the commentators are saying, oh, no, this is a death blow to Nintendo. No, this is exactly what's supposed to happen.
Yeah. Again, there's two things that are really unusual here. One is an allowance on a first action for an original case. That's extremely common for continuations and divisionals. Much more unusual for an original application, which I think this was.
Yep.
So that part was unusual. And then the director, for the subject matter for sure. For different art areas, it's not quite as unusual. But then for the director to also institute, we don't know this, but seemingly in response to public outcry, that just goes to show how vitriolic this was. I mean, you and I, that's why we did 2 episodes on it. People were really weirdly mad about this compared to, of all the,
we're doing 3 episodes on this. What have we done 3 episodes on in the history of this
character
podcast?
Copyright? That's it.
Oh, come on now. We did one on TSR and Dungeons and Dragons.
Yes, that's true.
But I think the thing that I had sort of, with this, and again, to me, the thing I thought was most interesting about this is it means the director was paying attention.
Yeah.
And quite frankly, that's a really good thing.
Yeah. or someone in his office was like, you need to look at this. This is, this is going on. My guess is somebody looked up the Japanese case and said, well, this is basically exactly, what the examiner said was missing,
Yeah.
or at least conceptually it is. Whether it actually, fills the gap completely is what we're going to find out.
Yeah.
But my guess is somebody in the staff saw that, brought it to him, and said, this is worth taking a look at. And he was like, all right, let's do it. And I liked your point, too, about, is this the director signaling, we're going to do more ex parte and less inter parte. We're going to stop throwing out patents that might be valid and just start fixing them.
Yep. Or it's not so much that they may be valid; they may have valid subject matter.
Yeah.
Maybe something that should be granted a patent.
Would
it just
be,
wasn't
yeah.
necessarily
Exactly.
granted to the correct scope, what it should have been initially. And to fall back on again our initial position, we talked about this. One of the problems you bump into with examination is the cost it takes to do it, and it only matters in important cases. And that means that always the examination isn't always done the best, just because they can't afford to do it. This is kind of pointing out, hey, this case actually appears to be important to the public as a whole. It may be important. Keep in mind, there is some pending litigation involving Nintendo and Pokemon video games. So, there may be some litigation sort of involvement around that. This is a case that maybe we should spend a little more money working on to make sure that this is actually correct. And again, the thing that I kind of bump into this is it's kind of somebody looking at it. The commentators, it's like looking at it and saying, hey, the initial product failed. The initial things failed to catch what it was supposed to, but the double check succeeded. That shows a failure in the system. No, that shows a success in the system. The double check's there to catch the failure of the front. That's why you have a double check. And that's what's really happened here is it's kind of looking at it and saying, the commentators were saying, hey, it looks like there's a failure in the system because this wasn't caught. And then the thing saying, well, yeah, there's a double check procedure. Let's use the double check procedure and see if it is. Was it really a failure or not? And that's the thing with it. I do think there's a little bit of a signaling aspect and again, to my mind, the thing about it is I think there's a signaling aspect because this was raised. It was raised in light of sort of media frenzy, and it was raised at the time the IPRs were being knocked down by this exact same director.
Yeah, that timing is interesting.
That timing is interesting, and I think does imply something that either implies, hey, we want to try to go back and fix things, or I've really kind of questioned whether or not this case should have been granted. As director, I kind of question if this case should have been granted. Really be sure. And that really be sure is a higher standard than most examiners would have.
Yeah.
So, because again, otherwise the director is potentially going to be mad at you if you screw this up. So that's why I'm pretty sure whatever they see as a rejection, or even if they happen to see an immediate notice of allowance coming back, it will be well thought out. It will be very well reasoned, and it will be well supported as to what it is. And quite frankly, that's good.
That is good.
Because that means that somebody looking at what this case covers has a better understanding of what it covers. That's the point. And so when you kind of look at it, and to my mind, the thing with this is this is the system working correctly. Again, I think we've seen commentators saying, hey, this was, Nintendo never should have been granted this thing. It's awful. Now they've been dealt this death blow as to whatever it is. No, this is the process working. Both headlines are wrong.
Trust the process, Kirk.
Yeah, trust the process. Trust the process.
All right, so we'll keep an eye on this as it goes through. One of the nice things about the ex parte re-exam proceeding is that it is conducted with what they call special dispatch, which is a funny
term.
Funny legal worm to say. Move your ass. Let's not drag this out forever. Which you don't normally need to encourage the patent owner, because while this is going on, the patent is, shall we say, tricky to enforce, but the term is still running. So let's get through it. So we'll probably know one way or other. And also, you should bear in mind, if it is thrown out in its entirely,
it's also a public proceeding, so it's one of those things
proceeding.
We'll all get to see whatever papers come in this.
If it's thrown out, Nintendo gets to appeal to the Patent Trial and Appeal Board. That is the same board that does the inter partes re-examinations. If they don't like their decision, they can appeal to the Federal Circuit Court of Appeals. If they don't like their decision, it can go to the United States Supreme Court, who will probably not want to take it on, but you never know.
Probably interested in it.
So we'll keep an eye on this, and this will probably not be the last episode we do. At a minimum, when there is a final decision in this case and we know what's going to happen, we'll probably talk about it then, and then maybe track any appeals if necessary.
Recognizing that may be a while from now. So
I would wager probably 6 to 12 months, which in patent terms is still relatively swift.
Yep. But yeah, so that's, I think, the thing we got from this is it's interesting for us to be talking about this because it's just, in some sense, we thought the vitriol and the sort of initial outcry in the media about this was interesting, which is why we talked about it in the first place. Now we seem like other people thought it was interesting and are now sort of doing the. We're now seeing the response back being interesting, And it just seems like a lot of people are interested about this. And a lot of what we were trying to put out here is let's really talk through what these procedures mean and what they are, because this is a far more nuanced thing than what a lot of the media is reporting on this, both in its initial statement of it being granted and in the statement now of it being re-examined, and what we're going to see from it. And, trying to get sort of good information out there. So hopefully you guys enjoy these. We have gotten very positive feedback behind the questions behind these. Obviously, if you guys have questions, you want us to talk about a particular aspect of the proceeding, something that I don't think we've ever talked about re-exam on the show before.
No, it's never come up.
It's never come up because it's really rare. We might have talked about IPRs at one point in time and sort of post-grant proceedings, but I don't think we've ever talked about re-exam. But if anybody's interested in sort of, wants more on that, we can definitely go into it. A lot of the reason we haven't gotten into it is because it's a rare proceeding, and it's got some weird esoteric rules, quite frankly, too.
Yeah.
But it's one of those things where, again, feel free to leave us comments. If you're also just 100% tired of us talking about this, let us know that too.
Yeah. Okay, so that's all for this one. Our next episode, we're recording here in November. If you've been living under a rock, you may not be aware that Stranger Things Season 5 is coming out. Kirk is trying valiantly to get through Season 4.
If you remember, I had only watched Season 1, and I hadn't sort of watched
the whole thing. And we did an episode on it, and then it kind of reignited Kirk's interest.
And so I went back and I actually watched part of Season 1 again, because I realized there was stuff I didn't remember from when we were talking about it. And at the end of having watched, I watched maybe sort of, I would say 3 to 3.5 hours of Season 1. At the end of it, I was like, that really was a good show. Maybe I should watch Season 2. So I then promptly watched Season 2.
All of Season 2. Kirk is the least binge-watching person in the history of the human race.
And was like, Season 2 is pretty good. It wasn't as good as Season 1, but Season 2 is pretty good. So then I went and watched Season 3, which was actually a little bit harder for me to make it through. I didn't really binge-watch Season 3. I finally finished Season 3. I was just on a flight, so I finished it on my iPad on the flight. And I was kind of like, Season 3 was kind of, I'm not too sure. There were parts of it I really liked. There were parts that I was like, do we really need the Russians? And then, so I kind of think, I'm like, well, now that I need to get Season 4 so that I can be ready for Season 5, because I'd watched the trailers for Season 5, and I'm like, I don't know a couple of these characters, so I need to find out what's going on here. So I watched the first episode for Season 4 and went, okay, apparently I really need to watch Season 4. Because the first episode of Season 4 is a
So we're gonna keep tabs on Stranger Things. Hopefully Kirk will watch Season 5 as well, which is coming out over the next couple of months here.
My goal is to be able to watch the actual series finale on the release day.
This is something new for Kirk, by the way, to actually watch a show when it's out and other people care.
What do you mean? I watch Star Wars.
We also Star Wars. As I'm waiting for Kirk to finish Andor, that he's been taking 5 months to watch.
That's because I'm trying to watch with my son, who's lost interest in it.
And then we've got an episode planned to go over a somewhat related topic in our Stranger Things episode. We had a throwaway line that we just came up with on the fly, but we were like, were the 1980s kind of a unique era in time to tell this kind of story? Like, why does that not work anymore? Why wasn't it done before? We have since thought more about that. We're going to talk about it.
Yeah, we're going to talk about it because it's actually something that when we started investigating it, we went down a rabbit hole, I would say safely. But that going down that rabbit hole proved really interesting.
Yeah, there's a lot of interesting stuff, and we're going to get into a broader topic of regulatory regimes that are imposed voluntarily by industries on themselves, such as the MPAA rating system and the ESRB. So look forward to that next.
And interestingly enough, yes, there are legal implications of why this stuff may have been set in the 80s.
Oh, yes, it is interesting. So that's all for this time. We'll see you next time. Lauren, play us out.
The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by Lewis Rice LLC, its officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer. This podcast was produced and recorded in St. Louis, Missouri.